So let's begin with the second hour. I will be presenting later on, but let's begin with the man who we've come all to see. Paul Kugelman litigates for and provides advice to agencies under the Virginia Secretary of Natural Resources and the 47 soil and water conservation districts. By way of experience, he's tried over 20 cases to a jury and has tried over 300 bench trials, taken and defended over 1,000 depositions, and handled about 20 appeals, including those taken through the Virginia Administrative Process Act. He has significant experience with ADR as well. His experience in the Virginia courts and the federal courts, including the Eastern District of Virginia, the Western District of Virginia, the District of Arizona, and the Fourth and Ninth Circuits. He has limited experience with the Supreme Court of the United States. He currently serves as an executive committee member of the Richmond Bar Association's Environment and Energy Law Section. You hear me now? Okay, sorry. I guess I'm gonna have to kiss this thing. He's also a trial advocacy instructor with the National Association of Attorneys General Trial Research Institute, and he serves on the American Bar Association's State Administrative Law Committee. Ladies and gentlemen, Paul Kugelman.
It's the nicest thing anybody's ever said about me, and it was all lost. Anyway, before we begin, I do want to thank Hutton & Williams for this absolutely lovely venue. Appreciate the State Bar allowing me to come speak today. And I do want to put a disclaimer out, as any good lawyer would, that the opinions and views expressed in this presentation are not that of the Office of the Attorney General. They are my own. With that, what I want to talk about today is basically effectively representing your client before an agency of the Commonwealth of Virginia. And how many people actually have an administrative law practice in any way? Awesome, good. There's like better than half. That's great. Okay, so this will have some relevance. Now, this is going to be basically a 30,000-foot view of APA law, what agencies are, what their actual authority is, their jurisdiction, how that melds into the APA, and what the purpose of the APA is, and giving an overview of it. And then I want to get into court review before I get into appearing before the agency. Chronologically, that's backwards, but before you can really understand how to effectively represent your client before the agency, I posit that when you understand how the court will review what the agency has done for, or depending on how you view it, to your client, you'll understand what you need to do before the agency so you can put your client's concerns in the best posture possible to secure an effective court review. And of course, I'll take questions at any time throughout the presentation. And I hope that I can meet Mr. Fortier's promise that this will be a robust presentation. That made me wince a little bit. Okay, so what is an agency? It's defined under the APA as any unit of state government empowered by its basic laws to make regulations or to decide cases. So what does this really mean? By definitions, agencies may be empowered to make regulations. Now, I have the quote here from the APA, but a regulation is basically any general statement or statement having general applicability having the force and effect of law. Requirements for gas tanks, how much effluent you can can be in the effluent you discharge into the James River, or how many fish you can catch, or what the hunting seasons are, etc., and so forth. General application. So really, an agency now has a form of some kind of legislative authority. By definition, agencies are also empowered to make case decisions. And basically, a case decision is more towards the person's level, and it's a determination as to whether a person is in compliance with a law or regulation or is entitled to a right or benefit, license, or permit. And they make those determinations. That's a case decision. So agencies also have a form of judicial power. Most agencies fall under the executive branch. Some fall within the judicial branch, some under the legislative branch, and some are independent. Anything yet. Executive, legislative, judicial, all being exercised by one body. So, don't we have a separation of powers problem here? We have one branch of government exercising all three powers. And even the Constitution of Virginia seems to have some troubles with this, or should have some troubles with it. Article 1, Section 5, and Article 3, Section 1 both basically state that none of the powers exercised by one should be exercised by the other. So how do we get to this place? Has it even been addressed? Of course it's been addressed. A lot of federal cases on it. Taylor versus World Enterprises explains it best based on the research I had conducted. And basically what it's come down to, according to the law, is that these aren't bright line separations. There's basically some blurring that's allowed to occur so long as there's a precise enough delegation that the courts can determine what has been actually delegated to the agency. And my feeling about this is that this was a necessary development in the policy of the law rather than a development in the legal context as an express legal development, although I guess that would make it express, but it was forced in my mind by the amount of involvement that the government has in our day-to-day lives. I don't know how many agencies would be involved just in the things that are in this room alone. And when the Constitution was written, these things weren't at the fore. So there were some adaptations that had to be made to preclude the legislature from having to become an expert in so many different areas. And it also provides the government with a lot of flexibility in dealing with these things in between legislative sessions. That's just my 2 cents, but that's kind of where I went with it. This is called the non-delegation doctrine, basically. And this is a requirement in order to pass constitutional muster. An agency's basic law has to have definite standards to guide the official agency or board in the exercise of that power. And if it meets that standard, then it's good to go. If it doesn't meet that standard, then it's unconstitutional. The reason I'm bringing that up here in this presentation is because maybe that's something you want to look to if there's a new agency created or as an amendment to a basic law as a potential challenge. That would be one way to effectively represent your client before the court. So now that we understand what the basic law is and the scope of what has to be delegated, the precision, what authority does an agency have? It has the authority to make regulations, and if you look in the definition of regulation, it has to be in accordance with the authority conferred on it by its applicable basic law, basically the enabling statute. So there's the constriction there for the regulations. The case decisions turn on a violation of such law, being the basic law or regulation, and in compliance with existing requirements. So again, it has to fall within the scope by operation in the case decision of within the basic law of the agency. So there's another thing to look for. Make sure that the agency isn't operating outside the scope of its basic law. And again, basic law is defined. Its basic law is provided for in the Constitution and the statutes to make regulations to decide cases. And basic law will also contain, on occasion, procedural requirements. And so you have the APA, which is the procedural requirement generally, and you have the basic law, which has different procedural requirements. And we'll get to what happens when these two conflict. So in summary, the limit of an agency's jurisdiction is confined by its basic law. And what's more, because they're entirely creatures of statute, they do not have any common law authority. So there's nothing else to look behind past the statute. However, I will point out that because these are creatures of statute, the rules of statutory construction do apply. And so when trying to figure out whether the agency is operating within the scope of its authority, like whether it can do something lesser than what it's been charged with respect to maybe a penalty, there are rules of statutory construction that allow entities, that read statutes such that if you have the authority to do up to X, you implicitly have the authority to do less than X, even if it's not expressly stated. So something else to look at when you're looking at whether an agency can do something here. Now, there was an interesting thing that came up, an interesting point that I came across while I was researching this, and it's called the primary jurisdiction doctrine. And this was something, I practiced law for 16 years. I was in the civil trial section of the Attorney General's office for 8, and I've been in the environmental section for a little over 2. And I've never come across this issue because I frankly wasn't aware of it. But when a case comes before a court, and either an issue or the entire case turns on something that's within the primary jurisdiction of a state agency, the court should, when it's just an issue, stay the case, remand the issue that the agency has primary jurisdiction over to that agency, let the agency decide it. When they get a final decision there, you bring it back and you take the case with the agency's input. If the whole case turns on a matter that's entirely within an agency's primary jurisdiction, the court, under this case, is required to dismiss the case, and the parties can do with what they want with respect to taking it before the state agency. So there's something to look out for before you go run into court trying to beat an agency over the head, and that's something for any government lawyers that are in here to look for, to maybe stay some proceedings and get things done properly. Okay, so now that we know what agencies are, what their authorities are, what their jurisdiction is, let's move into the APA. I want to just, when I'm talking about the APA, just do a really brief history of the Act. It's just 2 date points. Go over the purpose of the Act, and then talk about how the Act is organized. Basically, in 1973, I'm taking the second point up first, the Virginia Register Act was passed in order to satisfy basically public notice for state agency action. And when that was passed, the General Administrative Agencies Act was what governed process for administrative law. And then 2 years later, in 1975, the APA came into effect, and we've been operating under the APA since 1975 with various amendments, including some even last year. Basically, the purpose of the APA is threefold: supplement present and future basic laws, to make regulations decide cases. Okay, so there's 2. And then to standardize court review. And you see, the APA shall not supersede or repeal additional procedural requirements in such basic laws, which is what I was alluding to earlier about a conflict between the basic law and the APA. The APA yields way when the basic law conflicts with the APA. And there's a case, Marr versus Malveaux, from the Virginia Court of Appeals, that basically says that. All right. There's 6 articles in the APA. The first article is basically general provisions, definitions, things like that. Certain agencies are entirely exempt from the APA. 2 are the General Assembly and Virginia courts, interestingly enough. A third, one of my clients on occasion, is the Department of Game and Inland Fisheries. So you have certain agencies that are completely exempt. So if you're before one of those agencies, you need to understand they're exempt from the APA and look to their basic law, to its basic law, to determine how you need to proceed, because that's going to control entirely. Article 2 addresses regulations and the processes, what kinds of regulations you have: emergency, fast track, normal, or regular. There are agencies that are exempt from the regulatory provisions of the APA, including the Virginia Marine Resources Commission, among others. Article 3 talks about case decisions, and there are certain agencies that are exempt from the case decision provision of the article. Article 4 talks about the qualifications for hearing officers, when they preside, what their duties are, those kinds of things. Article 5 speaks to court review. There are no agencies exempted from that article. However, there are agencies that are exempted from the APA altogether, so I don't want that to be confused. And then Article 6 speaks to the Virginia Register of Regulations, which is the public notice component of the APA. All right. So now we have an idea of just the structure of the APA, what agencies do. Now I want to get into the court review, again, to fix the context against which you're going to measure how you're going to present when you're at the agency level. So I want to review the role of the court and the scope of its review, what relief you can expect, what you're allowed to get under the APA, and then just a quick walkthrough of the process to get a matter before the court for an administrative review. Under the APA, the circuit court stands as an appellate tribunal. So that means it's not a new trial. It's not like, oh, we'll go to circuit court and we're going to put on all the evidence again and all that kind of stuff. It's an appellate review, which means that the agency is actually acting in the role of the trial court. Now, I'm amazed. I sit as counsel on a commission, and lawyers regularly appear, and I'm amazed at how many say, well, maybe we just need to appeal this and get it before a finder of fact. Or maybe, we need to get this before a judge who actually has authority to enter a decision here. And of course, I'm sitting there thinking, really? Okay. But anyway, so the agency acts as a trial court. Now here's an interesting point too, and some folks miss this. I see this a lot. People come up with these great ideas between the time the agency makes its decision, its case decision, or passes a regulation, and the appeal to the circuit court. Oh, we've got these new ideas, we've got new theories how we can, how the agency erred. When you're appealing from an administrative decision, you have to present an issue to the commission, or to the agency to consider, or you've waived it. So have your good ideas before you make your presentation to the agency, not after you leave. Again, there's another case, Pence Holdings. It says the very same thing. If you didn't submit it to the agency for consideration, the argument is not preserved for later review. Now, with that, you're looking for court review. Who has the burden? Does the agency have the burden to prove that it was right, or does the person complaining of agency action have the burden to show that the agency erred? Well, the APA makes it very clear. The burden is upon the party complaining of agency action to designate and demonstrate an error of law subject to review by the court. Now, in 2.2-40, I can't read that there, but anyway, under that code section, that's a good checklist to start with, and it goes through some of the things that we've already talked about. Did the agency act in accordance with constitutional right, power, privilege, or immunity? Was it acting within the scope of its basic law? And what do constitutions do? With respect to the government, what does it do? Is there a distinction between the federal Constitution's grant and the Virginia Constitution, and how the Supreme Court views that? Just as a matter of background, of course everybody understands, because we all had con law in law school, that the federal Constitution is an express grant of power. And if it's not granted, Congress, the executive branch, the judiciary does not have that power. It's the opposite view for state constitutions. The Virginia Constitution, according to the Virginia Supreme Court, is a limiting document. So if the grant of power is not restrained and it's not in conflict with the federal Constitution or federal laws, valid federal laws, the General Assembly has the authority, the executive has the authority, unless it's otherwise constrained by the Virginia Constitution, which gets back to the original point about the separation of powers issue. But anyhow, then we've got, again, compliance with statutory authority, jurisdiction limitations, or rights as provided in the basic law. Again, is this in compliance with the non-delegation doctrine? And is it in compliance with the authority granted in the basic law? Observance of required procedure, due process. And then the substantiality of the evidence to support the findings of fact that the agency made, if it made any. In reviewing it, the court is required to review the whole evidentiary record with respect to findings of fact issues. So you can't say, well, on page 5 they didn't have enough facts to make conclusion A. It's the whole record. Now, there are times when the agency is not required to make a record, and I'll get into that in a little bit more detail in a moment. But even when the agency is not required to make a record and the court has the authority to order one compiled, it's still determined upon the basis of the agency file, minutes recordings of the agency proceedings. So even though you don't have an agency record per se, you're still pretty much limited to what you did before the agency. So typically when we talk about appeals, we understand that we have standards of review for statutory interpretation, we have standards of review for issues of fact, and we have standards of review that may differ if it's a mixed question of law and fact. And those apply in the administrative process as well. However, where the issue falls within the agency's specialized area of expertise, the court is required to give it the agency additional deference. So, for example, if you're looking at a situation where an agency is seeking to determine what a vessel is, and that's not within its area of expertise, and it makes us finding a fact or some conclusion based on the application of law, the court is not bound to give any deference to the agency. But, however, let's take an example from the Virginia Marine Resources Commission, which spends a lot of time managing fish stock up and down within Virginia's waters, but also in concert with the Atlantic States Marine Fishery Commission for all the stock going up and down the East Coast. And they make some determinations based on what's necessary to provide for a fish stock, or determine that a particular kind of fish falls under a particular kind of regulation. The court should grant those determinations substantial deference. Now, when a court makes the determinations, it's limited to acting in accordance with 2.2-4029 of the Virginia APA. So, court shall enter judgment in accordance with 2.2-4029. Now we're getting to what's available by court review. And unless an error of law as defined in 4027, which is the laundry list I referred to earlier, appears, the court shall dismiss the review action or affirm the agency action or decision. So if you don't designate and demonstrate an error of law in accordance with 4027, you're bounced. If it finds one, here's what it can do. It can compel agency action that was unlawfully withheld or unreasonably delayed, except that the court shall not itself undertake to supply agency action committed by the basic law to the agency. Again, we get back to the primary jurisdiction doctrine. The circuit courts there are precluded from taking unto itself the authority of the agency. But if it determines that there's agency action that was unlawfully withheld or unreasonably delayed, it can compel that action. And then if a regulation or case decision is found not to be in accordance with the law, the court may suspend the case decision or regulation, set it aside, and remand the matter to the agency for further proceedings, if any, as the court may direct or permit. Yes, sir.
Just a question. Can you give an example of the last point where the court cannot undertake to supply agency action?
I would submit that in the general sense, the court could not modify the case decision or the regulation. Like blue pencil or regulation, well, it would be fine except for this one provision. I'm going to take that out and then affirm. That's undertaking the power of the agency unto the court and exercising that authority. Rather, he would have to say, I find this provision troublesome, whatever, it runs afoul of the law, and he can either set it aside entirely, not in part, or he can remand it to the agency with instructions that this is not good law, this isn't in compliance with the law, and you need to do something about this. Try again, and we'll see what happens. Does that answer your question, sir?
Yes, sir.
So the point here I want to make, though, is this. You're either going to get something set aside, but that doesn't preclude the agency from taking the matter back up in a different vein. For regulation, anyway, case decision, much less likely. But if you get a remand, all you're going to get is really another bite at the apple. So when we're talking about, and I know this is going to maybe sound odd coming from a government lawyer, but your client's resources are at stake there. Because if you go up to the court and back down again because, okay, the court's going to give you a pass because there was other information that the agency needed that wasn't provided, there's a chance that it wasn't the agency that didn't provide it. So if you want to advance a position of your client before an agency, again, where the rubber meets the road is when you appear before the agency. You're not going to get a court to change the agency decision. You might set it aside, you might stay it, but the court cannot modify it. Here's another interesting point. I just had this on a case. The court cannot remand the agency decision until it makes a merits finding. And that'll make more sense in a little bit. And I'll bring that back up when it's appropriate. So there's a relief. Now, I just put the code section in there because I assume people can read, and I just want to summarize here. There's intermediate relief available too. Let's say your client's saddled with a case decision it does not like, or there's a regulation that's been passed and it adversely affects your client in some way, shape, or form. You can petition, you can appeal it, get it before the court, and under 4028 you can appeal for intermediate relief, which is basically seeking a stay of the imposition of the regulation or the case decision until the matter is decided by the court. So just know that remedy is available to you. I have never seen anybody seek it. but it's available. Another thing that you can do for your client, and this is kind of what takes some of the sting out perhaps later, is where you substantially prevail and the agency's position is not substantially justified, you can get attorney's fees from the agency and all of your costs back. The attorney's fees are capped at $25,000 and the costs are not capped. So you have a little bit of leverage with the agency if you have a good case perhaps. Okay, so we've gone over what courts can do. And basically the big ringer is you can't get the court to exercise the agency's jurisdiction. You can get a stay, you can get it set aside, you can get a remand, but you're not going to get something blue penciled or modified. Now, court review. So now we've got this case decision or regulation that your client is unhappy with, and they want to take it up to the court for review. Part 2A of the rules of the Virginia Supreme Court speak to the procedure about how to obtain court review. Part 2A is short, it's 5 or 6 rules. They're relatively easy to understand, and even so, it is a limited waiver of the Commonwealth's sovereign immunity. Without the APA, you'd just be stuck with the agency's decision, and that would be that. And because it's a limited waiver of the Commonwealth's sovereign immunity, thanks to 8 years in the civil trial section, you have to strictly comply with the waiver in order to continue to exercise it. Stray from that, and you may wind up out of court. The APA expressly authorizes the Virginia Supreme Court to pass rules to set the procedure up for prosecuting an APA appeal. So this is part of the waiver of sovereign immunity. Step 1, you need to file your notice of appeal. When do you need to file your notice of appeal? You need to file it within 30 days of the case decision or when the regulation is adopted. Now, as we sit here today, the state of Virginia law is unclear as to when the precise date of regulations adoption is for purposes of appeal. There was a case that recently went through the Virginia Court of Appeals. Its name escapes me right now. The court identified 3 potential points of adoption for regulation. It didn't tell the bar which one it thought was right because the appellant had missed all of them. So we didn't get an answer there, but right now I think you're going to see legislation introduced in the next General Assembly session that is going to specifically define what the point of adoption is for regulation for purposes of appeal to make that clear.
Sir?
Yes, sir.
Does that mean, and I had this issue in New York a long time ago, does that mean that if there are 3 possible timelines, you better, to preserve your client's interest, file on the earliest date?
If I were advising someone, tactically, I think that would be the right one to do. You certainly don't want to be the test case where you met the last 2 and they decide the first one's the right one.
Well,
I'm not trying to be flip, I'm just thinking out loud.
we were the test case, and it turned out we were right.
That's a good place to
You
be.
don't want to go through that again. So your advice, your informal advice would be, the sooner you can, preserve your, don't forfeit appellate rights by waiting to the last possible date, until this issue is decided.
That, I would agree with that.
Okay.
Basically, the question is, so how do we keep from running afoul and jeopardizing our clients' rights? Figure out what the earliest possible date is out of the points that, that the Virginia Court of Appeals pointed to and use the earlier one, and then you can't run afoul. But anyway, hopefully this next legislative session will fix a precise date so that everyone will know. The Notice of Appeal is really a very short document. It's usually a 1-pager. And paragraph B of Rule 2A2 sets forth what needs to be in there. You can put more in if you want, but you satisfy the requirements if you have a Notice of Appeal that meets all of that. And then the next step is filing the hearing transcript if there is one. There are informal hearings, there are public hearings, informal hearings, and formal hearings. And formal hearings, and I'll get to those in a little while, but formal hearings, when they're held, they have to have a recording of some kind, either through a court reporter or tape recorded. And so if a formal hearing was held, the appellant, the person complaining of agency action, has to deliver to the agency secretary with his notice of appeal, or within 30 days thereafter, a transcript. Now, what's interesting is the rule also gives the agency secretary the right to review the transcript and make corrections by an errata sheet. So there you go. just so you know that's out there. Step 3 is the petition for appeal, regardless of what the genesis of your appeal is, formal, informal, or a public hearing. 30 days after you file your notice of appeal. It's driven by when you file. So if you file on day 1, you file your notice on day 1 after the decision, you don't get 60 days from there or 59 days from there. You have 30 days from the day you file the notice of appeal. And you file that with the circuit court that you name in the notice of appeal. So you file it, your petition, and then the filing must include the payment of all fees and taking all steps provided for in certain rules under Part 3 of the Rules of Virginia Supreme Court to cause a copy of the petition to be served on the agency secretary and on every other party. I've had several cases dismissed because they served the agency secretary, but they didn't serve, somebody was challenging a permit that was issued, but they didn't serve the permittee or name the permittee as a party, and the judge said, yep, you missed it, you're done. Now, typically in practice, the petitions for appeal that I've seen are basically the opening briefs. And it's, in my mind, way overboard. The content that's required for the petition for appeal is set out in 2A4B. But I'll tell you, as counsel for the agency, if you want to give me your opening brief early, feel free. I'd love to have extra time to review it and figure out how to poke holes in it. But again, just a practice pointer there. So you've got your notice of appeal, perhaps the transcript with the notice of appeal within 30 days. Those go with the agency secretary, the petition for appeal filed with the circuit court, and you got to cause it to be served. Now, further proceedings. Agency secretary gets served with process and the petition for appeal. 21 days, this 21-day window exists where we can file motions to dismiss or to limit the appeal. And once any pleadings filed by the agency have been overruled, or if none have been filed within 21 days, the appeal is deemed submitted. Conspicuously absent from this rule is default. There is no default in an APA proceeding. It's not, oh, they didn't answer in 21 days, we win. No, it's just submitted. And once it's submitted, then the agency files a record with the court, and the court is required to establish a briefing schedule, and typically will also set a hearing date for the merits. As a practice point there as well, I encourage you to get with opposing counsel and all counsel for all the parties involved and work out a briefing schedule. It's going to be very simple. You have opening brief by the party complaining of agency action, the responses by the agency and whoever else is on that side of the V. Then there'll be the reply brief by the party complaining of agency action and anybody else on that side of the V. And then you have a hearing, and the court issues its order in accordance with 4029 and 4030, which 4029, again, is the scope of what the court can do with respect to the decision itself, and 4030 is a determination on attorney's fees and costs. Now, I hope I've met my goal here by going through the court review before talking about appearing before the agency. Again, now that we understand that the appearance before the agency is where the rubber meets the road, that's where the planning comes into place. That is the place where you make your record. That is the place where you make your legal arguments. That is the place where you put in evidence that you have or your client has standing to challenge the matter later if it needs to. And there's different ways to handle that for case decisions and for regulations, and we'll get into that in a little bit. The carry away here is, now that you know what is available through the court, you realize what you have to do in front of the agency. Regulations. There are normal regulations, which can take up to 2 years, and you have other regulations, emergency regs, fast track, exempt regs. Times are a lot faster under the other regulations, but there's also executive review. The governor's office has to review these regs, so sometimes vary dramatically. Basically, the process is the agency issues a notice of intended regulatory action, Department of Planning and Budget reviews it, sets forth a cost, impact cost, impact statement. The NORAs also gets public comment. Public comment is a place where you can make your record. So if you have a client that has a stake in a regulation or a series of regulations are being passed, be eloquent in your public comment. The agency responds to public comment, and then there's a draft that's required to be submitted to certain places, and then the reg can then be formally adopted, and then 30 days later it becomes effective, Anyway, this is in the notes. You're welcome to download them. If you can't get them online, feel free to email me at the Attorney General's office. I'll be glad to forward you the presentation. Adopting regs is very collaborative. The only places that I can foresee anybody really challenging regs is due process or outside the scope of the basic law. But if you have a stake in the case, in the regulation, you can usually get that resolved through the public comment and working with the agency. Appearing for case decisions, you have to know why your client is coming before the agency. And from there, you basically know what your plan needs to be. Is it a threatened licensure revocation? Is it an application for a license? Is it an enforcement action? Is it a lack of compliance action? And then you have to know the applicable basic law and agency regs to determine what you need to do from there. And you guys are all smart lawyers. I know you know what that means, but that's the plan you need to make. You need to talk with your client and figure out what's going on. Know the process, and then if you just look through these, informal, formal, summary, and subpoenas, the informal is required unless everybody waives it, but that's the case decision. Now, I'm not talking about regs. So you sit down, and the agency and the party kind of talk it through. The party lets the agency know why it thinks it should have whatever it's looking for, and the agency lets them know why not, and then there's a decision issued in accordance with the APA. Or you can waive that, or even if you get that, you can go to a formal hearing. Hearing officer may preside at an informal conference, required to preside at a formal conference, and that's very formal, cross-examination, evidence, blah, blah. Make your record, and you can go up from there. Summary disposition, you can read that, but basically it's like summary judgment. There are no material facts in issue. We want a summary disposition. The agency can decline to give that. That is not an appealable decision under the APA. And then if you need documents and stuff, you need subpoenas issued, you can ask the agency to issue subpoenas on your behalf. All right, thank you.